please permit me to read, Mass degree with 55% marks or an equivalent grade in a concerned relevant allied subject from an Indian university or an equivalent degree from an accredited so and so. Your Lordship can skip all that and please come to the note. There's a note appended to 4.1 at the next page, 53. The academic score as specified in Appendix 2 for universities, Table 3A.
What is net select? Starts with net select.
Under B. No, Lord, sir. There is a bold portion. The academic score it starts with. My Lord, have the academic score as specified in Table 3A for universities and Table 3B for colleges shall be considered for shortlisting of candidates for interview only, and selection shall be based only on the performance in the interview. There is no challenge to this words. So we will go to 3A or 3B as the case may be, if it is a university selection or a college selection. But just kindly, by your Lordships are at this page, please note, Lords, that there is a requirement of experience for the promotion post, which is Lords 2 associate professor subclause 3. So when you get promoted to associate professor, there is a minimum requirement of 8 years of experience as per the criteria given in Appendix 2. Correct, Lords? Now, Lords, please.
How do we read it?
Yes.
4.1. Then I.
Then I.
Then A.
Yes.
Eligibility is A or B.
A or B. And then there is a note.
Now, eligibility A starts with Roman 1.
Yes.
Roman 2.
Correct.
A, B, C, D.
Yes.
Provides no A, B.
I don't think it's my learned friend's case also that it will apply to, because we are not disputing the eligibility.
Just read B, what is B?
The PhD degree has been obtained from a foreign university with a ranking amongst top 500 in the world university ranking by any of the following, namely so and so and so. So in none of the repetition there is an averment that this applies to B, because it's a method of shortlisting. Whether you get PhD from India or you get PhD from abroad, when you come, you apply, we have to select some method of shortlisting. Because one of the methods of shortlisting is your past experience. I want to show that if you otherwise take a promotion, past experience is a statutory requirement in subsequent posts, which I wanted to show from associate professor, subclause 3. Note the next regulation your Lordship will kindly see is regulation 10 at page 87. This is a regulation where validity was challenged and it has been read down, so I read it a little carefully.
Where is the starting page?
Page 87. Right at the top is the heading.
Counting of past services.
87, counting of past services.
Is there. Where does it start? Or is it part of the same?
It's part of the same regulation. From page 50. Everything which I am reading starts from page 50. There are no separate regulations. So 10, counting of past services for direct recruitment, please mark this, direct recruitment, and promotion under CAS's Career Advancement Scheme. Now let's, previous regular service. This phrase has some relevance, whether national or international, and again, please see as assistant professor, because we are dealing with assistant professor, and others so and so, in university, college, national laboratories, and other scientific professional organizations such as CSIR, etc., should count for direct recruitment and promotion, both under the Career Advancement Scheme of a teacher as assistant professor associate professor, professor, or any other nomenclature provided. So the first part of 10 is, Lords, that past services must count for direct recruitment of an assistant professor as well. So we are okay with that, they are also okay. Now provided. Lordship can skip to Lord's A, B, C, D. If Lordship want, I can read it according to me, not relevant. It is C, E first. The challenge is to F, but I want you Lordship to see E. The previous appointment was not as a guest lecturer for any duration because they come for an hour or two, they teach and they go. Then see F. The previous ad hoc or temporary or contractual service, by whatever nomenclature it may be called, shall be counted for direct recruitment and for promotion, provided that A. 1. Essential qualifications were not lower, not concerned because she had the essential qualification. 2. The incumbent was appointed on the recommendation of a duly constituted selection committee constituted as per rule of the respective university. For insofar as this candidate or prospective candidate is concerned, we have no data. There is no pleading, no amendment that her past service was as per 2. And then comes 3, which is validity of alone, 3 alone is challenged. 10F3 alone is challenged. The incumbent was drawing total gross emoluments not less than monthly gross salary of a regularly, it was 5,000 at the time, then it was actually 45,000. Now let's how UGC treats people on contract basis is regulation 13, which is foot of this page. That's the third regulation. At the foot of the same page. Appointment on contract basis. The teachers should be appointed on contract basis only when it is absolutely necessary and the student-teacher ratio to satisfy the laid down norms. In any case, number of such appointments should not exceed 10%. Now look, this is what is relevant. The qualification and selection procedure for appointing them should be the same as those applicable to a regularly appointed teacher. This is also not under challenge. Fixed emolument paid to such contract teachers should not be less than the monthly gross salary of a regularly appointed assistant professor. Such appointment should not be made for period, etc. But we are not concerned with these 2 lines in Regulation 13. Because her case in the petition is that for the period for which she is claiming experience, she was getting 5,000 salary cash. Just kindly thereafter.
What was there on with regard to compliance of the top part of page 88?
Fixed emolument
Was to be only for one academic session.
There's nothing.
It can be the candidate can be appointed once again.
Yes.
Provided these requirements are fulfilled.
Yes. There's nothing. Nothing. It's a certificate notes by that college that she has worked. A 3-line certificate. I'll paste that out. The fourth and the last regulation is that table, which is referred to in the note appended to Regulation 4, which you will also find at page 100. Both tables are identically worded. One applies to university, the other applies to college. Lordship may kindly have a look at table 3A at page 2. So look, this is how we give marks. Marks for graduation, marks if you are a postgraduate, marks if you are an MPhil, marks if you are a PhD or a NEET, how much research publication you have, and comes number 7 with which we are concerned with. Teaching or post-doctoral experience, 2 marks for 1 year each. This post-doctoral experience High Court interprets to say that because there is a requirement of post-doctoral experience, you can't apply Regulation 10. I will read that part. And you go by the dictionary meaning, so therefore anybody who comes and says I have an experience, give them 2 marks. This is the not short reason. This is where she is taking 10. This is the, so these are the regulations not subject to whatever my learned can say. The question, my lord, which is framed by the High Court, you will find in para 17 and page 8. I want to read few findings of the High Court, my lord, then just do 2 or 3 submissions and I'm done. Para 17, may I read? The short question raised in this bunch of petitions is as to whether Regulation 10 and 3 would be applicable while awarding marks for the teaching or postdoctoral experience in terms of clause 7 of table 3 for shortlisting of candidates to be called for interview for the post of assistant professor in university. As a sequel, it has to be seen whether 10 and 3 is ultra-virus Article 14 of the Act. The findings of the High Court would start from para 23 at page 10. Those 4 or 5 findings and then those 2 submissions I have. My learned friend wants me to read 22. I'll begin from 22 if you're permitted at foot of page 9. A combined reading of clause E and F of Regulation 10 undisputedly reveals that E is that guest lecturer, that past services be counted for direct recruitment must not be as a guest lecturer for any duration. The essential qualification of post held was not lower than the qualification prescribed by UGC. Appointment was on recommendation of a duly constituted selection committee as per applicable rules. The incumbent drew total gross emolument not less than monthly gross salary of a regularly appointed assistant professor, so and so. So it reproduces all the regulations in one paragraph. The counting of past service under Regulation 10, however, would be relevant and correlated directly to the post on which direct appointment or promotion under career advancement scheme is sought. Since past services are required for appointment to the post of associate professor and professor only in the regulations, the relevance of Regulation 10 would be restricted to these posts alone. This is the first finding, Lord, which according to me is clearly contrary to a plain reading of 10 because also of 4, because 4 and 10 read together, my lords, give marks for 4 and table 3, and the manner in which those marks are to be awarded is there in regulation. This is the answer to Lord's finding in paragraph number 23 insofar as I am concerned, that 4 read with table 3A have a requirement in them to consider past experience. No previous teaching experience, including assistant professor, since is required as an eligibility condition for appointment to the post of assistant professor. As such, Regulation 10 would have no direct applicability relevance for appointment to the post of assistant. Now, my lords, if your lordships can skip this, my lords, and come to para 27. Finding if your lordship can just have a look at Regulation 10 also once again, because I'm sorry to take your lordship back. Page 87. previous regular service. So this would apply to somebody who is working as an assistant professor in some other university. As assistant professor, Professor so and so should count for direct recruitment, then please skip as assistant professor.
Of a teacher as assistant.
Correct. So it is not that the regulation doesn't require. Apart from note appended to regulation 4, regulation 10 also requires. So then kindly come back to Lord's para 27 at page 10. That's the second finding. May I please have by the respondent university or colleges. It transpires that the teaching or postdoctoral experience for award of 2 marks of each year, the respondents have applied regulation 10. 2 marks towards teaching or postdoctoral experience for each year has been allowed to a candidate only if such teaching is inconsistent with regulation 10. Even where a candidate has taught for a year in a recognized institution, yet he would not be entitled to 2 marks unless the incumbent drew total gross emoluments not below the monthly gross salary of a regularly appointed assistant professor. Because I think your Lordship will have to take it as an argument, because otherwise this finding is contrary to all other findings in the High Court. I'm not next paragraph, but this was important to read because the High Court draws a parallel from this. Teaching or post experience occurring in clause 7 of table 3A has not been defined. It is for this reason that the respondents have referred to and read provisions of regulation 10 of the regulations into it. This interpretation of the respondent is a bone of contention. 10 specifically deals with a defined exigency. This is the finding. That is counting of past service for direct recruitment and promotion under the career advancement scheme. This exigency is not attracted in the present set of cases. Regulation 10 has a direct nexus with the object sought to be achieved. That is direct recruitment and promotion under CAS. Since past services are mandatorily required for appointment of post of associate professors and professors only, the regulation 10 would have relevance only for appointment and promotion to such posts. Then PC 30 lots. This is adding to the regulation. Reference of past service, which I just read, regulation 10 to your lordships, on the post of assistant professor for appointment to the post of assistant professor appears to be a surplusage, since the eligibility for the post of assistant professor does not require any teaching experience.
So once the High Court says regulation cannot be assistant professor.
Yes.
Does it say that whatever marks have been given to the other candidates on account of experience should be excluded?
No. What the High Court says is that you recalculate everybody's marks, redraw the entire list based on dictionary meaning of what is past experience and not by what you have calculated by following.
So once you say that regulation 10 is not relevant for assistant professor.
Yes. They say the table 3A. No. High Court 3A. Table 3A has column 7. Look, can you see that again? At page 100.
Or 10 says counting of past service for direct recruitment or assistant professor also.
Which High Court says is extra. It's been, according to High Court, because in the paragraph which I just read.
That is excluded by the High Court in para 29.
Yes. Para 30, it says it is a surplusage.
Para 29 is reiteration of para 24.
But para 30, it says it is a surplus. Yes. Under para 31, the High Court tries to explain. We are persuaded to take such a view as reference to teaching experience in table 3A has to be read in conjunction with postdoctoral experience. There is a slash between teaching and postdoctoral experience, as they constitute a composite class in itself. In the event regulation 10 conditions teaching experience, as is suggested by the respondents, the term postdoctoral experience would also have to be necessarily conditioned by regulation 10. This, however, does not appear to be the intent of the scheme contained in the regulation. There was nothing, Lords, to suggest this. And the regulation 10, Lords, just note this. It says counting of past service. It doesn't say a counting of past teaching service. It's very important notes to address this argument in para 31. The heading of regulation 10 is counting of past service and not counting of past teaching service.
That has to be read with this note in bold letters.
That's right. That's my argument. But independent of my argument, High Court says it is surplus, number one. Number two, it says that it refers to postdoctoral experience, that table. Therefore, Regulation 10 doesn't apply. But just look at the heading of Regulation 10. It says counting of past service, and it says services IR, ICAR, DRDO, UGC. These are all services, my lords, which can be, my lords, counted towards a person who is applying for a postdoctoral experience.
And there is no challenge to the note.
There is no challenge to the note.
High Court has also
Only 10F3. Only singular challenge is to clause 3 of Regulation 10F.
the past experience is not required as an eligibility, as a eligibility,
Gotcha.
but that has been made impliedly required under the note.
Note. And I have an additional argument that as a university, so long as I do it uniformly, I can have an additional standard, so long as I follow it for everybody.
But you have been permitted under the
Yes,
note.
that's my first argument. But alternatively, my lords, I am in any case entitled to follow the same procedure, even if UGC doesn't apply to me. So long as I do it uniformly, there is no allegation of discrimination. But I wanted to show the heading of Regulation 10 with past service and not past teaching service at page 87. It's very wide. Then it goes on to para 30, etc. to say what you mean by postdoctoral experiences. I don't think that was even a list before the High Court. But therefore, please come to my lords para 34. Only a page and a half. In our opinion, regulation, may page para 34, I'm sorry.
Yes.
In our opinion, Regulation 10 of the regulation would be attracted only where past services are required to be counted for direct recruitment and promotion under the career advancement scheme. It cannot be transposed to be made applicable in a criteria for shortlisting of candidates to be called for interview to the post of assistant professor by any recognized process of interpretation. Such construction otherwise is not carried out from the scheme contained in the regulation, nor it helps in shortlisting of candidates to be called for the interview. Because I just gave data about number for one post. We have got 69 candidates who actually comply with Regulation 10. And there are another about 200 who don't, above her. My Lord Justice Datta has para 35. Table 3 specifies the marks to be awarded to a candidate on different parameters specified therein. Apart from awarding marks for graduation, post-graduation, so and so, table provides teaching/postdoctoral experience of 2 marks for each year. Since the term teaching/postdoctoral experience is not defined, the ordinary commonsensical meaning would have to be assigned to it. This is the third finding of the High Court. High Court says teaching experience as a full-time teacher in a recognized university or its affiliated or constituent colleges with requisite qualification as per regulation for the post of assistant professor would sufficiently entitle a candidate to award of 2 marks for each year of a teaching experience in clause 7. Now, please mark this, very important. Nature of appointment, that is whether substantive ad hoc, please mark this, guest, which is specifically prohibited. Lecturer, etc., or amount of salary paid having not been specified in clause 7 are not relevant for the purposes of awards of marks in clause 7 of table 3A. And please see the ultimate mandamus, which are the last 4 lines of 37. The respondents would henceforth shortlist the candidates to be called for interview for the post of assistant professor in the manner indicated in this judgment. for all the posts, whether it is language or otherwise. Language.
Interfering with that process by which you have called candidates
Court says
who have crossed
I'm sorry. Court says selections already made.
the process which has been started by this and
So, Milord, that was one interpretation because they say on the line above that, selections already.
page?
At page 96, Manoj, annexure B3. This is my advertisement dated 21st of November 2022, Manoj. So by this advertisement, I have invited applications for the post.
My performance is that 45.1. 45.
Business information and data 105 in my.
You know what it is?
Page 105 is part of annexure C1.
Yes.
Well, look, I have invited applications for 133 posts, of which 132 was for assistant professors for various subjects. The remaining one was for a librarian. Now, this is the advertisement, my lord, we kindly have page 98. Page 98. Well, look, clause 8 or serial number 8, I have specified that minimum education qualifications. The applicant must fulfill the essential requirements for desired post, assistant professor, college, so on and so forth, and other conditions stipulated in the UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for maintenance of standards in higher education 2018. So I have specified that UGC 2018 regulations would be applicable. Now, Manoj, we kindly have clause 10. In clause 10A, Manoj has specified that mere eligibility will not entitle any applicant for being shortlisted, called for interview to appear before the selection committee. In case the applicants are more in numbers, only the shortlisted candidates shall be called for to appear before the selection committee. And on B, I say that screening and shortlisting of applicants for appearing before the selection committee will be done as per UGC regulations 2018 and subsequent amendments made from time to time before the date of advertisement. Now, Manoj, we kindly have 17, clause 17 on page 99. Page 99. Only the shortlisted applicants will be called to appear before the selection committee. The interview shall be bilingual. The subjects of music short has to carry instruments, and these shortlisted candidates will be called in the ratio 1:8. That is, up to 8 shortlisted candidates will be called upon one vacant post. A minimum of 3 eligible candidates is required to holding meeting selection committee. Now, this was in line.
So in your college,
Yes,
there was only one vacant post.
there were 3 for subject of Sanskrit, Manoj. Otherwise, there were 132 vacant posts for various subjects, including
We
Sanskrit.
are concerned only with Sanskrit.
Yes, Manoj.
Sanskrit, 3 vacant posts.
Yes.
How many unreserved?
Manoj, 1 unreserved.
One
I'll
is
just give the numbers, Manoj. 2 unreserved and 1 reserved for the scheduled tribe.
2 unreserved. So you are required to call with the ratio 1:8, that is 16. 16.
3 total posts vacant, Manoj. 2 unreserved.
2 unreserved. You have to call a minimum of 16 candidates.
Yes, sir.
So what is the stage of your process?
Well, it was challenged. Therefore, I have not gone ahead with the shortlisting candidates for interview for
So
this.
you have gone ahead with the shortlisting also.
Yes, sir. Manoj, we kindly have at the bottom of the page 99, serial number 23, Manoj.
Yes.
Clause B would be relevant for the purpose, the current purpose, Manoj. On page 100. Each applicant claiming for undergraduate, postgraduate teaching experience shall submit a certificate from competent authority to the effect that the applicant has been working in a UGC recognized institution on a regular basis with UGC pay scale, a self-certified copy of 6 months bank passbook along with pay slip should also be attached. So I have published everything, whatever was required from any candidate, therefore everyone was put to notice for this. Now, my lord, kindly have the writ petition which they have filed, which is page 103, annexure P4. And I just draw my lord's attention to the prayer which is on page 145 in my writ petition. Page 145 is where the prayer starts. The relevant part is on page 146. Page 146. Prayer A is only limited to challenging the vires of regulation 10. And prayer B is only for quashing of clause B8, which says that 2018 regulations would apply. There is no challenge to 1:8 ratio. There is no challenge to we calling upon pay slips or any other record as per serial number 23 of my advertisement. Now, so far as I am concerned, and what I understand is that it's a two-way process so far as selection is concerned. The ultimate selection would happen on the basis of interviews, and for the interviews, there are two steps for a person to reach the ultimate stage of interview. The first one is screening candidates from all the applications received. That screening would happen as per regulation 4 of the 2000 regulations, and the second step would be to shortlist candidates for sending for interviews from the eligible candidates. And that would be done as per note appended to regulation 4. So far as the applicability of regulation 4 in the note is concerned, the learned senior has already submitted the submission. I just wanted to point out a distinction in facts that I have done. That is it.
The first assembly, kindly have the first assembly. Page 54. The page 54, regulation 4 lays down the minimum qualification for the assistant professor. It does not require the past services. It only lays down the minimum qualification. The candidate before your lordship has passed all the examination with first division except intermediate, BA, MA. She is PhD and she has also cleared the NETs. So she is a brilliant candidate. And if 10 marks had been given, I will address on that issue. Then, admittedly, in Allahabad University, the cutoff mark was 87 point something. And if had been given 10 marks, then I would have got 91 marks above 87 the cutoff mark of the Allahabad University. Now, kindly turn to page 87. The very limited dispute was there, and I think my learned friend has not addressed that issue before your lordship. The regulation 10, only I will read the first, it's titled Counting of Past Service for Direct Recruitment and Promotion under CAS. Now, the offending clause, which we have challenged before the High Court, it's ultra virus, is F, 10F. Kindly permit me to read it. The 10F and 3 entire 10F, the previous ad hoc or temporary or contractual service by whatever nomenclature it may be called shall be counted or direct recruitment for promotion, provided that essential qualification for the post were held not lower than qualification. They said that there is no problem with the clause 1. The 2 says the incumbent was appointed on the recommendation of a duly constituted selection committee constituted as per rule. They had no objection that my past service as a contractual service was not in terms of 1 and 2. Now the only
There is no pleading. That is what the specific contention is.
they have never raised any.
There is no pleading in your rate petition that your past service is as per Roman 2. Clause F.
We have stated that we were appointed following the rules and they have not contradicted it. Even in the hearing.
Where have you written that in your rate petition? Which paragraph?
And we have
Where have you stated that?
we have challenged only 10F3. Para 5, the petitioner had a teaching experience on page 161 from the from the Dwala 161, where she was appointed and the letter has annexed. And it was renewed. She was appointed for a further period of 3 years. As taught, the period has been mentioned. And in counter affidavit, they don't say that the rule has.
So you don't say that. Where have you said that? You were appointed. That is the only statement.
They have not denied that I have not. The procedure has not been followed. They have not.
No, this is the repetition which has succeeded. Page
They are all by the common order. All 3 by the common order.
The division bench has 5
The repetition number
580 is what my learning field has shown.
Where was that particular provision under challenge?
Yes. But
What is that repetition number?
580, which my learning field.
580. So 580, paragraph 5 says that she was appointed on contract and the appointment was renewed from time to time.
Correct. Doesn't say
Nothing more than that.
I think even the first repetition counted page will find it page 130. One. Zero it begins. They will see the order.
110 is the first repetition.
Yes. At 115. Arrival.
Mr. Goel, page 87, 10F2.
Got you.
What were the documents you required to satisfy this criteria? Where is that clause that how the documents are to be submitted?
No, that is not there, but it will be there in the appointment order. Or the advertisement pursuant to which your contractual employee.
Previous ad hoc or temporary or contractual service will be considered provided the incumbent was appointed on the recommendation. Now, to exclude somebody who has not been appointed in the manner required by 10F2, how do you come to that conclusion?
Basic government to begin with?
Forget about writ proceedings.
Yes. Then
One has applied.
yes. So
What is the requirement under your advertisement?
the advertisement by which contractual employments were called for, Lords, and the appointment letter.
Where is that clause that you need to produce these documents?
It's not there.
No clause.
No, it's not there. And in the it's a matter. I'm sorry.
There is no clause. Mr. Goel concedes that. But to take the advantage of 10F2, what did you produce?
Good. Finally, similar. In SLP at page A and in the counter affidavit before the High Court, they say that you do not fulfill the criteria of 10F3. They have never said about 2. There is no even then we have
His petition, he has
and
In your complaint before the High Court, did you raise the point of ineligibility for NF2?
no,
You did not.
No, we're just pointing out that his petition doesn't say that he was validly selected for a period of 1 year as per the UGC guidelines, which is the requirement of tenant. For denial is not to be held against him. He is claiming relief.
Actually is only on ground of 10.3, not 10.2. Even in the SLP they say it is only page A. Even in the SLP they say.
Rejection as you obtained 81 marks.
Well,
That fixed the cutoff of 87. So you did not reach 87. That is why you were not shortlisted.
because I was awarded 81 marks, they excluded my 10 marks. Now,
So
I have 3.
What did you submit in support of 10
3 Milord.
F3?
Milord, yes. Kindly have Milord.
What was submitted by you?
10.3 Milord, I have submitted my certificates, my appointment letter, etc. Now, finally, Milord, page 57.
Of the SNP? 57 of the SNP?
Yes, Milord. Page 87, Milord. Because
Page 87 is the
regulation.
First, let us see. What did you say? What did you submit before the authority pursuant to the advertisement?
All right. Annexure R1, the application. To that, all the details have been given.
25 of our answer.
This is yes, which page?
Page 25, Milord's annexure R1. This is our application. 25.
Where is the relevant column?
Page 26, at page 26, almost in the middle, you will find 3.1 full-time teaching experience. Now, as a lecturer on contract basis from 16th October 2004 to 27th March 2010. So it is a 5.5. This they have admitted that I have a teaching experience of 5.5 years. You should kindly permit me only to read 10.3 entire clause because that was not placed before your lordship. And that is the only dispute in this case with the division bench has decided. 10.3 entire clause. The incumbent was granted total gross emolument not less than monthly gross salary of the regularly appointed assistant professor, associate professor, and professor as the case may be. Now the division bench says that on contractual, a regular salary is never granted. Therefore, I was given 5,000 rupees, and they say that since the regular salary of the assistant professor is 35,000, and you have received only 5,000 per month, therefore 10 marks will not be given. That is the only the dispute in this matter. And my experience is I have never come
when you have seen the advertisement, which requires you to comply with 10F3, why did you not challenge it?
I challenge it in the
But you failed.
Before the division bench.
So let us now see the 3 petitions that you have filed. What did you challenge there?
Before the division bench in special appeal, I took a leave to challenge the virus of 10 PF, and that application was allowed, and that's what the division bench has allowed my petition. Because
if you come to Mr. Goel's note, first petition is 7114.
Here they are at page 127.
That is there. Just go through your note. So when you filed 7114, the university was not counting your past service.
yes, sir.
So you filed a writ.
One of
That the past service should be counted.
my writ petition was dismissed because I did not challenge that the virus of the 10 PF.
127, let us see. What is the order?
Here,
Here.
Prayer. 127 is the prayer.
Oh, no, there. Where is the order?
Yes. The order note by the
148.
Yes. But kindly see the prayer at 127.
127.
Yes.
Clarifying.
128 is your prayer. Where is the order?
Relevant part at 148 notes.
It is a single bench order.
That's correct. Begins at page 129. Annexure P3.
So against this, there was no appeal?
No,
Yes.
against which there is an appeal. The appeal
Where
was
is
filed.
the order? Where is the order on the appeal?
The impugned order is a common order.
In this, one thing more, Mirror. Kindly have mirror page 172. I filed a writ petition before division bench, another writ petition, page 172. In Allahabad High Court, if the virus is challenged, then the matter goes before the division bench. I filed a writ petition number 16585 of 2022 before the division bench challenging the virus of route 10.3F. Now the division bench says, my lord, at page 173, at the bottom your lordship will find, may I place it correct? Page 173, paragraph 7. 173, paragraph 7. Kindly have note that paragraph. In our opinion, the question of considering the candidature of the petitioner for post of assistant professor Sanskrit advertised on existing UGC norm regulation 2018 has already attained finality by the rejection of the claim of the petitioner by order of learned single judge, telling the bodies of regulation 10F3 regulation and general instruction is pending consideration. So I moved an application, and on that ground, my third application was dismissed. And now that application, the learned division bench, by a common judgment, has disposed of all that by
Therefore, the only petition where the virus was directly under challenge
my lord.
was this petition at 172, which is being disposed of.
Yes, and in the pending special
In the pending matter, you had paid for leave. So
I got
therefore,
I got on.
in exercise of appellate jurisdiction, the writ court exercised original jurisdiction and granted you leave to challenge it.
My lord.
Division bench also.
Division bench also allowed me, my lord. This and my writ petition was dismissed.
This petition was dismissed.
Yes.
So therefore, there was no original challenge to
There
Rule
is.
10.
In the third petition, there is.
This is the third petition.
That's 580. Page, writ petition.
Well,